Hey folks, welcome. It's Dave Brannen here to another edition of Ask a Lawyer Live. I'm going to be here for the next hour or so, just answering your questions and giving you a little brief presentation on employee rights related to, what is our topic today? Employee rights related to probation periods. That's what it is. It's late in the day, folks. Give me a break. Give me a break. All right, let's take a peek here. What we have. So again, today we're going to talk about employee rights for probation periods. These would be the periods starting off an employment where there is a period of time where employers can let you go. We'll talk about all that. Apart from that, tomorrow is Thursday, so we'll do a call-in show. If someone wants, you'll have the opportunity to phone in. The phone number will be available during the call, so you can call in. We can talk back and forth. I can answer your questions a little better. So if you have any burning topics you'd like to discuss with a lawyer, now's your chance to do it tomorrow. I'm probably going to be taking, I'll be taking Friday off again this week just to work on other things. And then we'll be back next Monday to do this all over again. So let's take a look at probation periods in Canada. And it looks like, okay, just making sure my sound is good. People will be telling me when my sound is bad, so that's all good. Let's take a look at probation periods in Canada. Here we go. So what is a probation period? It is a time at the beginning of employment where an employer evaluates the employee in terms of their job performance and the like, and they can terminate the employee from the role without giving any notice of termination. So it essentially means it's a short period of time, usually short, where the employee can evaluate you and terminate you without having to pay severance pay or give you notice of termination. Now, there are two types of probationary periods. There are statutory, which come through Employment Standards Acts across the country and the federal employment standards, or it can come from the contract itself. That is important to understand. There are two types of these probationary periods. Now, according to provincial and federal laws, if nothing is written at all, then there is a probation period cannot be more than 3 months. So if nothing is mentioned at all about a probation period, then there can only be a 3-month probationary period allowed to employers. Now, no termination pay is required if you are let go during a statutory termination period. And there's been no misconduct. And by that, I mean misconduct of the employer. We'll get into that a little bit further. Contractual probation, on the other hand, can go longer than 3 months, but it has to be clearly set out in your employment contract. It can't be ambiguous at all. If it's ambiguous at all, the courts will just revert back to the 3-month that's available under the employment standards. Now, the other thing is the short contractual probation periods, they can't go beyond, and they can't take away other rights that you have from the statutes and things like that. So just keep that in mind. But they can go longer than just the bare 3 months. Now, what rights you have during a probationary period? Some people think they have no rights, but you do. You still cannot be discriminated against under human rights laws, and you still are entitled to be employed in a safe workplace. So if there are workplace safety violations, that will be something that you still are protected from. And you can be still, even during a probation period, you can still be entitled to termination pay if the contract says so. So for example, like contracts can waive a probationary period. So even though there might be a probationary period through the statutes, through the Employment Standards Acts and such, your contract may waive any probation periods, and you're allowed to do that. So it's always important to see what your contract says and what the employer is allowed to do. So common misconceptions are, like, the big one is people just think they have no rights at all during the probationary period, and that is not true. The biggest thing to realize is that you can't be discriminated against for human rights violations. And that is one of the big ones we see, that where people have been successful. If you've been terminated during a probationary period, if there's a discriminatory purpose around it, then you get full rights to both compensation for having your rights violated and also termination pay. Okay, so legal standards when they're looking at termination during a probationary period, it's easy for employers to do it. There's not a big bar for them to get over. Basically, the court just has to be satisfied that there is no bad faith or like by bad faith it means there's just some really ulterior motive that could really be tied up with things like discrimination, something like that. The employer does not have to have a good reason. They don't have to have any reason. They can just not want to continue your employment. It has to rise to the level where there's a real bad purpose here that they're trying to the most common would be that they're trying to discriminate against you. So after probation, once you get past the probation period, even if it's just by a day or an hour, at that point you're entitled to notice of termination without pay. And that's the biggest thing. So sometimes there can be disputes about whether you're in the probation period or you're after it. Sometimes employers will scramble to fire somebody before the probationary period ends, but maybe they've calculated it wrong and you're already out of the probation period. So sometimes this boils down to determine, a certain number of days. Are you in? Are you out of the probation period? We've also represented people in a person in a case where they actually got the probation period waived in their contract and the employer must have forgot about it because they later tried to terminate them based on them being still in the probation period. But that turned out to be not correct because the employer had actually waived the probation period. Okay, so practical tips to protect yourself. The big one would be having a copy of your employment agreement. I can't stress this enough. Otherwise, when you go to see a lawyer after you've been terminated, a lot of information will kind of be up in the air because if you don't have a copy of the contract, it's hard to know what the rules are that are going to apply to you. Also, just generally speaking, it's good to document any performance reviews that you've had. That can be important because if there is some argument that there's a discriminatory purpose for you being terminated, if you can point to the fact that you had positive performance reviews during the probation period, that may lend more validity to your claim that there's been discrimination. And certainly if you've been dismissed during a probation period, it's worthwhile getting legal advice. Sometimes there's not a lot a lawyer can do in most of these cases, but again, if it's a situation where there's been discrimination, then absolutely a lawyer can help in that type of situation. All right, you can get our free guides by downloading them. They're listed down in the down below below the video in the description. There's links to our videos, and also you can contact us for a free consultation. The number there is on the screen if you want to call that, or you can go to our website and use our chat, or there are forms you can fill out also to request a free consultation. I'll see you back here next time. Okay, that's the end of that part of the presentation. Let's dive into questions from people, if anyone has any, about probationary periods or really any topic you want. I'm going to be here for the next while. If there's no questions, I always will end the day early, so just keep that in mind. But if you do have questions, feel free to put them in the chat now, and I'll give people a second just to put them in. I'm going to take a peek and see. It's always a good opportunity now for me to answer questions on the forum. I run the Canadian Disability Claim Forum. I'll show people what the forum looks like here. I'll just share my screen. I'll just show you what it looks like. So this is what the forum looks like. Here we go. So this is the forum. Switch my screens up so I can see what I'm doing here. Here we go. And I got to share that. So boom. This is the forum. If you've never been there, this is not for employment questions. This is where people can go and ask questions to others who are dealing with disability claims in Canada. I own the forum and moderate it. My staff at our law firm moderates it. It is intended for people to get answers from others who are dealing with non-lawyers. It's for you to get answers from other people who are going through what you are, not for lawyers to kind of come in and tell you what the right answer is to everything. Every now and then I will monitor this, and sometimes people tag me to come in and answer a question. So I will do that. But it's interesting just to go through and see some of the questions and things that are on here. Like this might be an interesting one. What's this one here? So this person is saying, the insurer sent me a consent form labeled 5 of 5. So they sent them a 1-page labeled 5 of 5. I signed it, but put a note that I did not agree with whatever the other 4 pages were since they did not send them. Yes, I agree with that. The claims adjuster replied that the original form I signed at the beginning of my claim had the other pages, and I can just refer to the previous document. Thing is, the form I signed originally, I still have it, and it's different and does not have the page numbers on it. Yeah, I did not receive the other pages at the beginning of my claim. Today, the claims adjuster sent me a letter claiming that I had to sign the form without any modifications or they're going to cut me off. In summary, it appears the insurer is trying to force me to sign a document without seeing all the pages under threat of cutting off my benefits. Is this legal? Definitely not legal as the way this person is describing it. So I'm just going, let's just assume everything they're saying is 100% correct. If you get sent a document saying 5 of 5 and you are not, and it does not include the other pages, it is completely appropriate to do what this person said and say that I am signing this page based, but not agreeing to whatever the 4 of 5 are, like he said. If an insurer were to cut off your benefits like this would be considered bad faith, where they are trying to hold you to documents that are not there. Like this is just a very bad look. I don't think the insurer would cut this person off for this. I think this is just kind of like a claims representative who's going too far and probably would get reprimanded for using this type of a tactic. Now, that being said, I often do recommend that people go ahead and sign a lot of these claims forms. I tell people just to go ahead and sign them, even if they're not ideal legally in terms of like, sometimes you don't legally have to sign some of these forms, but I tell people to do it anyway. It's often more beneficial for you to be cooperative and allow the process to unfold than to enforce your legal rights and kind of gum up the works or throw a wrench into the works. Just, it isn't always in your favor to throw a wrench into the works for a bunch of reasons. So you want them to adjudicate your claim. You want later decision makers that get involved who come from the outside, like a judge or a mediator. You want to be seen as someone who was cooperative throughout the process. And so it doesn't always help you to throw a wrench, even when you legally are allowed to throw a wrench in. So again, I think this person did it the right way to say that they are not going to agree to pages that are not there. And like they said, they looked at the pages that they think the person was referring to, and they didn't have page numbers on them. So I would not agree to sign it. It sounds like what's going on here. I don't know anything about this situation, honestly, although it does sound familiar. So maybe this person did contact my office as well, or as a client, because this does seem somewhat familiar. But in any event, usually, in my experience, when a claims adjuster comes to you with a weird request like this with threats, it's often because they're trying to cover up their own mistake. Like maybe this person's under pressure why they didn't get this thing signed. And so now they're acting out like this because they're the ones that are in trouble and they're trying to pressure you to do what they want. None of this makes any sense. I don't see any of the big insurers endorsing one of their employees to act this way and to make these kind of statements. I just don't believe that would happen. So I think if I was to guess, I think this is a claims adjuster who's trying to cover their own ass, if I might say so. But I don't know that for a fact, obviously. All right, let's go back here and see if there's anything else interesting we can look at. What's this one here? This one says, okay, so this one says, I was recently approved for CPP disability. Will be getting my first payment next week. Not yet got any paperwork from CRA, but I know it's been approved. Okay, it comes from Service Canada, not CRA, but that's just a technicality. Since applying in September, one of my children turned 18 and they're still a full-time student. But before I send it, does the payment have to go to the bank account that's only in their name? Okay, I see what they're saying. So the issue here is, again, I'm not 100% sure on the policies for Service Canada. But once children turn 18, Service Canada does have a policy, I believe, that they do want to send the money directly to the child. But I don't know if that is like 100%. So what I would recommend to someone in this kind of situation is, rather than kind of try to figure it all out, just contact Service Canada and ask them, what do they want to do? So that would be the thing. Probably this person's just trying to figure out before they call to try to figure out what is the right thing to do. And I guess what they want to know is, what bank account do they put on the form? And they don't want delays and things like that. Yeah. The problem here is, well, let's scroll down and people might know the answer. They're saying keep the money separate. It's rare to find a policy that allows. Oh, wait a minute. They're asking about clawing back child's benefits. Okay, I missed this part down at the bottom here. It said, I realize that the payment now goes to them, but my horrible LTD manager is saying the insurance company has the right to claw back all the children's benefits. So I don't want my child to blow the money in case they make me pay it back. Yes, that is completely correct. Can I just put my banking? I would tell her to put her banking information on the form. Yes, 100%. Especially if there's going to be an issue with having to pay back these funds, because yes, LTD can claw back children's benefits. LTD can claw back children's benefits. So until that gets straightened out, you definitely don't want your kids blowing the money, 100%. So I would fill out the form and put your own thing in there, and you can sort it out later for Service Canada to switch it over. Because again, they often want to switch it over to pay to the children. Now, how it works, I saw someone comment here, like, your kids are on disability too. No, that's not true. How it works with CPP disability is a benefit payable to an adult between 18 and 65 who meets the test for disability, the requirements for disability. If that person also has children, then those children qualify for a benefit just based on the status of having a parent that has a CPP disability. So it's not based on the kid's disability. The children there's a supplement payment called the child's benefit that is supplemental paid on top. So each child, there's a supplemental payment. It is money that belongs to the child. So when the children are under age 18, the money goes to whoever is the designated caregiver for the child. But after age 18, because it's money that belongs to the child, the money is supposed to be sent to the child. So that's why this person is trying to figure out whose bank account information and all that. But it's not the kid's disability. That's a common question that people have. This person says here, it's rare from my perspective to find a policy that allows insurers to claw back the child portion of the CPPD. That is somewhat true. But not completely. So what it's rare to see, the way these long-term disability policies are written, there's two ways they can deduct benefits. One is called a direct offset, and then there's an indirect offset. So not to get too complicated, think of the direct offset as what you normally think of as a direct deduction, where it just lists a bunch of things. And if you have any of these things, it's just a dollar for dollar deduction from your benefit. Normally, children's benefit is not listed there, which is probably what this person is referring to. However, there's a second part of the deductions clauses that talks about all sources, income, and this type of thing. That is usually where you'll find the ability for them to deduct the children's benefits. So the all sources section of these group policies, it basically says that we do have these direct deductions. However, all sources of your income cannot exceed 85. It's usually 85% of your pre-disability income. If all sources of your income exceed 85%, then we will reduce your LTD benefit dollar for dollar until your LTD benefit plus all your other sources together equals 85%. So what they'll do is they'll include the children's benefit in the all sources calculation. And then they will say, okay, if we add these children's benefits into the all sources, does it put them over 85% of their pre-disability income when you include everything, including the LTD? If so, they will reduce the LTD down until the LTD plus the CPP plus the children's benefits does not exceed 85% of your pre-disability income. Kind of complicated. I've given this talk to lawyers who also can't figure it out. So if this does not make a lot of sense, then I completely understand. But that is basically where it's going. This has been fought. There was a court case in Ontario where they tried to challenge this to say it just was basically saying it should be illegal for the insurance companies to deduct the children's benefits, especially where these benefits are sometimes not even paid to the person. Like if the children's over 18, then the benefit is paid. The benefit is paid to the child. So, but those were overturned by the Ontario Court of Appeal. They basically said no, that this is legal to do as long as it's clearly written in the policy. And basically, the Court of Appeal said they can do it, but it has to be clearly written in the policy that the word child's benefit has to be written in the policy. Or it has to be written in a way that it makes it clear that all types of CPP benefits are deductible, not just your own benefit. Apologize, I'm going to sneeze here. All right, let's take a look at some more here. This one is saying, can I work while on persons with disability? And so this is a common question. Persons with disability, that is the provincial disability and income assistance in British Columbia, I believe. So without going directly and looking at it, generally speaking, you cannot do a lot of work and get benefits from the provincial. Now, they all have their own rules, but each province would have kind of an income threshold by which you could earn money up to this level and still qualify for benefits. And so you'd have to go. Now, this person said here, it says this person has responded and said in BC, a single person can earn about $16,000 a year. Anything above that is deducted. So that's where you have to go look. So most provinces do allow you to earn some amount of money, just like CPP disability does, and still collect disability benefits. So, all right. That's a good question. And then the person asked, would I be cut off if I go back to work? And again, this Caro person is correct. Not cut off, but if you earn more than the maximum. So if you go back to work, you could be cut off. They'll look at two things. They'll look at how much are you earning. So if you're earning less than, in this case, they're saying 16,000. I don't know if that's correct, but we'll just go with it. If you're earning less than that, then that's one thing they look at. But if you're working, they also will consider whether you have the capacity to earn more. So just because you're not earning more than 16,000, being back to work is evidence of capacity to work, and they will assess whether you could work more if you wanted to, type of deal. So it does kind of open the door. If you're working and getting benefits, it's just something you have to carefully manage when getting disability benefits. But there's nothing wrong. Many people can work to some minimal level and still be qualified for disability benefits. That's a very common thing. Most people don't think that. Most people think that to get disability benefits, you have to be completely, partially because of the wording of it. It says totally disabled, but it doesn't really mean totally disabled. It's totally disabled as defined by the policy, which doesn't really fit with the general idea of what it means to be totally disabled. When people think totally disabled, you think of someone in a quadriplegic in a chair who's got attendants caring for them and that kind of thing. That is not what this means in the context of disability benefits. What else we got here? This looks like an interesting one. Oh, let's look at this one here. Tribunal level. Ooh, it's a long one here. So I receive LTD and RBC since 2021. Not sure what RBC is. Usually that's Royal Bank of Canada, but anyway, had both knees replaced, having hip issues, advanced OA, thumb injury, no family doctor. That's always a problem. Okay, this person's now at the tribunal level. CPP, I guess CPP tribunal level. Okay, they're at the tribunal level and they wanted a more detailed report to deal with the prognosis. The prognosis means how are things going to be in the future. Prognosis is very important. That's a medical term, but it's very important in CPP disability because you have to prove your disability is not only severe, but it's prolonged. So the prognosis relates to the prolonged part. Many people will lose a CPP disability case because they do not have enough evidence that your current disability, no matter how severe it is going to be prolonged. You actually have to have evidence to prove that. So this person's saying that their doctor is reluctantly and rudely refusing to say that this person's going to be out of work for a long time. Okay, he's thinking the doctor wrote he could go back or she could go back in 2 years. I'm asking CPP to send me the application the doctor sent. I think I may need a rheumatologist. Yeah. So here's the problem. Here's the problem. Sometimes when you get a doctor to fill out a report and send it in, you have like this person has no idea what the doctor wrote on the report. So you don't even see what they wrote, and the report went into. I'm not sure how it went into. Yeah. Usually when you're at the tribunal level, you control all the information. So it sounds like what happened here is this person went to their doctor and the doctor wrote the report to Service Canada. But if you're really at the tribunal level, you will see that report because Service Canada then would provide it to the tribunal and the tribunal would give you a copy. So at the tribunal, you're going to get a copy of this report in advance. Now, this person is on Royal RBC, which would be Royal Bank Ltd. And when you're getting, so this person's saying, should I get a lawyer to help me? The issue with that is when you are on receiving LTD, it is hard to get a lawyer who would be able to work with you on like a no win, no fee type of situation. Because if this person is successful with their CPP claim at the tribunal, then pretty much all of the back pay is going to go back to the Royal Bank, in this case, the LTD provider. So what happens in these cases is, I know with the big three, like Sun Life, Canada Life, Manulife, I'm pretty sure all three of them, and Blue Cross as well, they all have arrangements with advocacy agencies, not necessarily law firms, but with disability claim advocates and agencies, some of which employ lawyers as well. But they hire these agencies to represent their insured people in these CPP disability claims. So what I would say is for the person like this in this situation is to get in touch with Royal Bank Ltd. And ask them to hire one of these agencies to work with you. Yeah, this person's stressed and afraid. It is a very bad situation to be in. So it sounds like they're not at the tribunal level yet. They just got notified of the reconsideration decision. So what happens is when you apply for CPP disability, you get denied. You do a reconsideration. That happens right with Service Canada again. That gets denied. So that's where this person is. And then you need to apply to the tribunal. If I was this person, I would really be trying to get the Royal Bank to hire one of these agencies to work with you, these advocacy agencies. That way, Royal Bank will pay the advocates to help you, and you don't have to try to do this alone. The problem is with getting a lawyer, lawyers will do this, but you'd have to pay out of your own pocket and not be reimbursed by Royal Bank, unfortunately. But the problem here is like this person has two problems. They're wanting to get a lawyer and they're also wondering about the medical, what the doctor said. I would tell this person, once you appeal to the tribunal, you are going to get a copy of whatever your doctor has written into them, and you will have time to respond. Just make sure when you apply to the tribunal, you indicate that you don't want a hearing immediately. A lot of people say that because they want a hearing as fast as possible. But if you do that, you take away your chance to get more information to review the file. So when you file your notice of appeal to the tribunal in a case like this, then what will happen is they will write back and they will send you the complete file from Service Canada that will include this report that your doctor sent in. So you'd want to see that report, look at it, and then do what you said. If you think the report is not fair and accurate, you could go and you could take a copy of it to your rheumatologist and get your rheumatologist to give their opinion, and then send that into the tribunal, and then that would go into your tribunal case. All right, I'll do one more question and then we'll call it a day unless people have any other questions for me. Let's see here. Let's look at these and see if anything grabs my eye here. All right, what's this one here? No one's answered this poor person. So maybe what I'll do is answer it here and then I'll go and type them an answer as well. This person says, does the request to appeal at tribunal letter need to be complicated? New medical information is straightforward. I feel like I'm putting in too much time with the request letter. They don't care what really have to say. Wonder what anyone thinks about this. Okay, I know exactly what to tell this person. So I would tell this person, the most important thing is to just get the notice of appeal, request for appeal form to the Social Security. You can say on that form that you must, you can say on that form that you will provide more details later. So when you fill in a lot of these forms, they want you to, you don't have to put your full argument and information. You can just say more details to follow, or I plan to get more records. You'll provide more details later, and that you are still gathering medical records and evidence. There you go. So I'm just going to sign off this. The biggest problem people run into is they will delay too long, trying to do the perfect thing, or not knowing, or just being too paranoid of what to put. And so you don't have to try to win your case with these notices of appeal. You just want to get them in. That is the most important thing. Then you build it. So what we do is we will do these notices of appeal in like 10 minutes. The case manager at our firm will just fill it out. They send it to me. I review it, sign it, ship it, kind of thing. We just put we put in all the information you need, but when it says like reasons for appeal, we just say we disagree with the decision. Basically, that's all we say. We says, do you want a hearing? Right? We put don't want a hearing right now. We want a hearing once. We'll indicate when we're ready for a hearing. We indicate we're still gathering more information in medical and send it in. It will always be approved. Like this isn't something where they're going to deny you, but you don't have to try to write. We don't write detailed reasons, because once you get to the tribunal, this is your chance where you get all the information. Once you apply to the tribunal for CPP disability, the first thing the tribunal does is collect all the records from Service Canada and give them to you. So you just want to hold back. You don't want to give all your reasons or write out the appeal stuff until you read over all the stuff, including all their internal notes and everything. So you get to see everything. Then you can decide, okay, based on everything there, we want to get this extra information and bring it in. And once we have that new information, and then we can give our reasons and submissions, written submissions to the tribunal. Oh, there we go. No worries. So I guess one of these that we went over was yours. Probably not this one here, but yeah, no problem. If you have any follow-ups, just let me know and I can answer them here. Let's see. Maybe we'll do one more. Let's do one more. If people have any questions. So what we're doing, if anyone's just joined us, I'm Dave Brannen. I'm just here doing questions and answers portion of my daily live stream. I'm an employment disability lawyer. And what I'm looking at right now, this is my firm's, we manage and sponsor this forum. I've run this forum for many, many, many years now. This forum is intended, it's the Disability Claim Forum. It's intended a place for people to go and get answers from other people who are going through the same thing you are. But I still like to go through here and I'll put my comments in. Sometimes people tag me to give my comments. And all I'm doing right now is just going through and looking at some of the questions in here and just giving answers. This is a public forum, so nothing in here is intended to be private. I think I've already dealt with this one here. So here's one here. So we just talked about that. This one says, we talked about the CPPD being handled by a consulting company. So what we're talking about here is when long-term disability insurance companies, when you're on an approved claim, many of the long-term disability insurance companies will hire a consulting company, an advocacy group. There's different names for them. But what they are is there are groups who are experienced with doing CPP at different levels of experience with dealing with CPP disability claims, and they will help you. It's in the insurance company's interest to get you approved for CPP disability, so they pay these advocacy groups to help you with your application. And this person's wondering if it's, let me just see here. I've been on LTD on the past. Okay, so this person had help with a consulting firm. I've been denied and am now at the tribunal level. I've not seen my application or spoken with anything from CPPD until last week. Okay, so this person was just having questions getting in touch with the firm, and they're getting worried. That would be a very big concern for me as well. So I think what you have to do here is just try to reach out to the consulting company, and if not, contact your insurance company, because they will definitely want to know if the consulting company is not doing what they should be doing. My understanding is with these, I guess it would matter, but most of them are going to see you through to the tribunal, I believe. But maybe some of these only will go to, like, they only do the appeals up to the tribunal. I'm not 100% sure. So that's something you'd want to get clarified. Some of these consulting companies are very good. And the others, I just can't say whether they're good or bad. I don't know their work, but I do know the work of some of these companies, and some of them are quite good. Yeah, and so people are just giving advice. Is that the same person? Yeah, no, people are just giving their advice. So what's this person saying? I'm presently going to the tribunal. I have little information. Why denied? Just not prolonged and indefinite. I looked up the navigator option, and it's University of New Brunswick law contact to represent. Wonder if I have to get a lawyer. I'm still waiting for a response. The navigator, so if you run into a navigator at the tribunal, that is a position that the tribunal has put in place. The navigators are not there to give you legal advice or anything like that. They're there just to explain how the process works and to facilitate you to know what to do next, but they won't advise you what to, like, they won't tell you what, they'll just tell you the next step is for you to submit documents. They won't tell you what documents to submit. They just tell you what the next steps are and try to point you in the right direction. I don't know what they mean, the UNB law contact. Maybe there's free, maybe what the navigator did is, navigators will usually give options for free legal assistance. I don't think the navigators will recommend lawyers like paid services. And maybe the UNB Law School, they have a legal clinic. I'm assuming that is what's being talked about here. They were probably given information to contact the legal clinic, the free legal clinic at UNB Law, to help with the appeal. And that is probably what's going on there. Okay. All right, folks. I appreciate everyone that's shown up. If anyone, I'll give you a few more seconds. If anyone has any questions they want to post in the chat, just post the questions in the chat. If you have a question for me about anything, I've just been going through some of these forum questions, which I think I'll do on days like this when there's not a lot of questions coming in. I can kind of answer some of these questions on here. So much stuff on here. All right, I'll leave it there. It's good to see everyone back. I'll be around tomorrow. So if you have a legal issue that you'd like to talk over with me, you're comfortable doing it in front of everyone else, which not everyone is. But if you are, it's a perfect opportunity for me to get a lot more information and we can go back and forth talking and answer your questions. I'll probably have some, I don't have any presentation planned for tomorrow, but I may have some things I want to go over and then we'll just dive into questions. And that's about it. I'll see you all back here tomorrow and I hope you have a good night.